Over the past 3 decades, he's built a respected practice focused on professional liability and real estate litigation. He also serves as an expert witness in professional liability cases. Mark is a member of ABOTA, the American Board of Trial Advocates, an invitation-only organization that admits only the most accomplished trial lawyers who exemplify civility, integrity, and skill in the courtroom. In addition to his litigation work, Mark serves as a mediator, drawing on his experience as both an advocate and a neutral to help parties resolve their disputes. Today, he'll be speaking with us on Help Your Mediator Help You, and we're very happy to have him with us in the San Fernando Valley Bar, and we appreciate his insights. So with that, Mark, please take it away.
All right. Well, thank you. I'm happy to be here and happy to see a lot of familiar faces in the on the Brady Bunch family windows that we've all become accustomed to. I had this idea about the topic, from starting my mediation practice, 2.5 years ago, and as I went through the training to get on the panels that I'm on, I really tried to study and thinking of all the mediators that I've been in front of as a litigator, and trying to learn the techniques, and thinking, geez, I really need to to make up some ground on being in my skills as a mediator. And then what I found as I started doing these is, really it's just kind of the basics is what dictates if a case gets settled or not. So, I found a lot of lawyers that would, come to the hearings and just not having done some of the basic things. And so that's kind of the spawn or the impetus of this presentation. And then I'm going to pepper it with some ideas and things that I've learned and have developed over the years. So for today, our goals, we're going to talk about how preparation improves our outcomes. And I'm going to try to go over some practical steps as to what people can do, especially if there's some newer lawyers in the group here, as to what you can do to try to enhance your odds in a resolution by starting early in the process. And then hopefully I see we've got some mediators that's seasoned mediators. Maybe we can share some war stories and best practices. I'm going to leave a little time for Q&A. And so that's my cue, no pun intended, to write them down, get ready. We're going to save some time at the end where we can have sort of a discussion about what works and what hasn't worked in your own mediation preparation, either as a litigator or as the few mediators that we have online here. So I find this, too often than I would like. It's, mediation, as I hope we all know, isn't just show up and settle. The settlement is more likely to happen when both sides are ready. And what I mean by ready is not just have a mindset of settlement, but of ready as in having gone through the documents, having done the things that we'll talk about to be able to know the facts of the case and on both sides, not just one side. As I just talked to an attorney today about a mediation that I'm doing later in the week, and kind of an obvious point of the case. And I asked him, hey, it's on a commission dispute. Hey, what's this point for, why are you making this demand, for this amount of money? And he didn't know. I'm like, well, I'm going to see you on Thursday. And it's a $200,000 claim and the item is $99,000. And so, I'm super glad I made the call, because we would have wasted a lot of time during the mediation to try to get to the answer to see if the case could get resolved. Again, we want to set a tone of resolution, and being prepared, I think, really helps with that. It's again saves time during the mediation, and I think it reduces posturing, because what I find is when people are not prepared, they just sort of get stuck on positions because they just don't want to admit. Maybe they don't want to admit to their clients. They don't want to admit to the other side that they just don't know what the answer is, or they don't know the information that is important to resolution. And so they take positions and they get rigid in those positions just because they don't really know what the right answer is, or what the evidence really says. And then, we going through looking at some of the names in the group here, we all remember when mediation was in its infancy, where we actually had to pick up the phone and talk to the other side about resolution. Where a lot of times now we just say, well, we'll let the mediator resolve the case. But if you can have the joint preparation with your opposing counsel, you develop a bit of a trust, and that you can have a working relationship towards resolving a case. That's really overlooked an awful lot. I find, when I ask, okay, what kind of conversations have you had regarding settlement? And most often the answer is none. Again, it's important to really know the cases. This seems to be obvious, but I find it more often than not. The lawyers aren't familiar with all of even the main issues in the case. Forget about kind of the nuances in the case, but it's really important to know the case well, because you're going to be trading arguments throughout the case, and if you don't know the factual basis to counter their arguments, again, we get hung up on not being able to find where the commonality is. All right, we all agree that these facts are what they are, and then what does that mean? What's a jury going to do with those facts? Often I'll ask, what happened in discovery? Well, how did they answer that in discovery? And they won't know. So, going back and getting fresh with the discovery responses, knowing what's actually pled. Is there a claim for attorney's fees? Even on business cases, I get stuck with that. So now we've got to go and try to pull the pleadings during the mediation to try to find out, okay, what are actually the claims and aren't, what they aren't. And and I didn't put this on there, but in my personal practice, when I have a case and I go to the cases first and try to put all those elements, as part of my initial evaluations of cases, because we think about it as trial lawyers. That's really what we are ultimately going to have to present to the jury, are the elements in the cases. And I kind of try to approach my mediations the same way. I'll ask the lawyers, what are the proof elements that you're going to have to show here, and what do you have the evidence for these points or not? And so looking at the pleadings and understanding what your elements are prior to the mediation is really is conducive to settlement. And then, of course, you got to understand what your client really needs out of the case and what their limitations are. If you've oversold your client, it's going to be really hard to settle a case at mediation. If your client wants the moon and you can't deliver, you've got to have that conversation prior to the mediation. And there's been plenty of times where I've mediated a case where I honestly was shocked at how blunt a lawyer was with the client. You can't get that. We've talked about it 100 times, and the client, really is pushing, and the lawyer is reeling them in. And then, of course, I've had the exact opposite, where I get a sense the client really just wants the case resolved, but the lawyer is pushing for more than what the client wants. But having the lawyer and the client on the same page is really helpful in trying to get a case resolved at mediation, and that obviously requires an honest evaluation of strengths and weaknesses. And then, I always encourage litigators to have that honest conversation with the mediator. I mean, it doesn't mean that just because you concede that you're weak on a particular evidentiary point, that the mediator is going to run over to the other side and say, hey, you're going to win on this point. But it really helps for the mediator to be able to understand where you're going with the case and help you sort of coach you on how you can get through the negotiations with that in mind. I find that a lot of mediation briefs that I've seen are just sort of like an opening statement. They're just narrative of what the case is about, but really the devil is in the details. And rarely do I see the actual documents that are going to be key to a case that are part of the briefs. I mean, it's super important. And I would say especially in PI cases, all the medical records and how you're calculating damages, and we'll get to how it affects insurance in a minute. But collecting all the contracts, invoices, if you're in a business dispute, if there's communication, getting all the key emails. It takes so long to try to gather emails if there's a dispute as to what was communicated and when it was communicated, to try to hunt through those during a mediation, to be able to get a summary of those and have it be available in advance of the mediation is so helpful. The old adage, a picture is worth 1,000 words. They should have key photographs available to be able, and preferably exchanged with the other side, and we'll get to that in a minute. For the personal injury attorneys that are part of the groups, part of this group, the medical records and getting the medical records I think is just key. I've known some really top plaintiffs attorneys in my time, and most of them will, at the very beginning of a case, will tell defense counsel, send me over your authorizations, I'll sign them, and then you'll get, of course, you want to get copies as to whatever defense counsel gets, but that's your key to getting a big recovery, right? You've got to give them information so that they can give you money to resolve the case, and having that exchange done early on is certainly helpful. And then having your damages calculations done in advance, and having the other side know how you're approaching, not just making a number, but understanding how you get there, especially when there's insurance involved. And I have a slide on that. Insurance coverage, knowing what's covered, what's not covered, what the issues are, is super important. If coverage counsel is going to be there, I would always like to try to have a position from coverage counsel as part of the brief. I did a mediation some time ago, and there was a coverage issue, and as soon as the coverage issue resolved, I knew the rest of the case was going to resolve in just a few minutes, and sure enough, that's exactly what happened. And so it's understanding what insurance is available is always an important part in mediation. I'm probably, everybody's saying, well, duh, it's obvious, but often that issue is overlooked in advance to the mediation, or coverage counsel thinks, well, I'm not really involved in the underlying matter, so I don't need to be there. Visuals, timelines, especially timelines if you're in a business dispute or real property dispute on a transaction, are very helpful. Okay, I sort of hinted on this, having the conversation with the client, explain the process. Clients really, come in these mediations, and a lot of times they're really nervous. Explain the strategies that you might use. We're going to talk about an anchor offer, which for those of you who don't know, an anchor is making a demand that's either much higher than that you're ever going to collect, or much lower than that you're ever going to stick to, and you do it for strategic purposes. You don't want your client to be anchored on the anchor, so make sure they understand. And one thing, and this is why I have it in bold, so often people just don't do the math, especially in injury cases. How much is my case potentially worth? How much do I have to spend in experts? And actually, do a budget. I'm going to hire this doctor. I got to have this orthopedist. I have to have this neurologist, whatever the case may be. And then add up what all those are going to cost, and then figure out what your client's net is on sort of your best case scenario. And then when you get into mediation, have that number in mind, because if you get up close to what your eventual recovery is going to be, that's a great settlement, even if it's a much less than what you think the jury is going to return. You got to focus on the net, and a lot of times attorneys haven't done the math, so they don't have the net in mind. Litigation is never certain. Everybody who's tried a case, juries do weird things. And so have your client be prepared for best case scenario worst case scenario so that they have their expectations set, because we all know that that there's no perfect settlement. Is everybody has heard and probably has repeated that a good settlement is where everybody walks away equally unhappy. The What I find too is the intangibles, the stress of being in a mediation where you're talking about injuries that really affect people or in a wrongful death. And now you're talking about money. And so the client is there and you're reducing either that client's loved one's life, or you're reducing their inability to work to dollars and cents. And it's not humane, but it's the process, right? That's the only way that we have to settle disputes. So you need to prep your client, because often what will happen is the client will just get so full or fed up with that process that then they become rigid and recalcitrant. And they just want out of the process, and so they stick to a demand. And they don't look at anything else other than wanting to get themselves out of the situation. So think about the emotional and non-monetary factors and have that conversation with your client. Okay, so defense counsel, for those that are involved in insurance here, you got to have a number. You got to talk to your claims person prior to the mediation, strategize as to where you might want to go, and have an idea as to what your authority is. If your authority is limited for whatever the reason may be, have that conversation with the mediator, because maybe that isn't the scheduled time for the mediation might not be right if there's other coverage things or authority reports that need to happen. Consider what kind of ranges that you might want to fall within, and whether what I mean by fallback positions is maybe you have an idea of a mediation of, okay, well, I've only got a limited amount of authority for whatever the reason may be. Maybe we go in, we try to resolve certain portion of the case and then reschedule and see if we can do what needs to be done and mediate the case again. I've had a lot of mediations where we find that things need to happen before we can come to have a good chance of resolving the case for an amount that everybody's happy with. And so think about those creative ways, maybe of doing it in steps, having the mediation done in steps. For claims people that are out of town, think about when you schedule a mediation. If you got a claims rep who's on the East Coast and you're setting a half-day mediation starting at 2:00, that claims rep is going to be unavailable at some point during the mediation. So think about setting the mediation earlier in the day so that you don't have your decision maker out of your reach. And then also understand levels of authority. And I'm just going to talk about this generally, and I'm sure a lot of people know this, but I also find a lot of people don't know. You may be dealing with an adjuster that has X amount of authority, 100,000, and then after 100,000 in authority, that adjuster needs to go to the supervisor to get additional authority. And then, after $500,000, whatever, then there has to be yet another supervisor that needs authority. And every time they need authority from somebody above them, they have to do what's called a large loss report, which means that your adjuster that you're dealing with has to put together a multi-page report and submit it to their boss, and then their boss has to do another report that's similar and submit it to their boss. And so that takes time. If you have tell the adjuster before mediation, you send in your pre-mediation report a week before, and the adjuster says, hey, I think we need 120 grand to settle this case. And the adjuster says, well, geez, my authority is at 100 and I haven't done my large loss report. Well, you haven't given your adjuster enough time to be able to help you to do what needs to be done to be able to settle the case. And with the magic of a swoop, you can see the rest. And the same with plaintiff's counsel. you need to understand this process. If you make a huge demand within a week before the mediation, you may not be giving defense counsel what he or she needs to obtain authority. That's where I go back at the beginning where I talked about this. Have those conversations at the beginning of the case. Hey, I think this is going to be, I'm going to be asking for X amount of dollars, and have that conversation, even if it's, hey, you're crazy, you're never going to get that amount. You can have a civil conversation about why you think that you're going to be able to get that amount of money. And I have an example, a war story that I'm going to show you in a minute. If you think that you're going to make a significant demand, you need to make that demand well in advance, and to be able to get all the people that in line that need to be that need to do reports, to give them time to be able to do their reports. So with that, I'm going to show you a case, that one of the few plaintiffs cases that I've handled, that I had a couple of years ago. My client was the guy on the motorcycle that you can barely see, with the red car on the back, and actually they had to use the jaws of life to pry it out of the white car that's in front of it, and it resulted in this surgery with the hardware that he was anointed with, as to fix the damage to his back. So the driver was a young kid, 22. He had been involved in 3 rear-end accidents in the 22 months preceding this. Well, this was the 3rd. So he had 2 prior accidents within the prior 22 months. The dad was extraordinarily wealthy. He had a unique insurance that catered to wealthy people, and they had $1 million coverage with a $10 million umbrella. And so I think with a lot of attorneys, the approach would be, I'm just going to show up at the mediation with these 2 photos, and I'm going to get a lot of money out of this case. Well, you might be surprised that the settlement offer I got prior to the mediation with these facts, a rear ender with this injury, was about $200,000, which really didn't even cover the meds. And so the understanding or trying to understand what's going on with the insurance company, they had also moved the case from their boutique counsel, that 10, 15 lawyers, they moved it to 1,000 attorney firms. So I knew they were worried about the case. They also did some sub rosa on my client, and that also made me think that they were worried about the case. But offering 200 grand doesn't seem like they're worried about the case. So they did the IME, and the IME doctor said he was trying to whitewash the whole thing. My guy had played football in college, and so he did have some prior revision surgery when he was in his 20s, and he had some prior neck problems for a few years prior to the accident. And he was trying to say it's all just degenerative work or injuries, and try to just pass it all off onto that. So I called up a buddy of mine who's an orthopedist that does a lot of defense work. And for all you plaintiffs' attorneys, I highly recommend you have a defense expert in your stable, because they will tell you how the defense is going to think about your case, and give you ideas on how to get around it. And so he told me I have to get a diagnostic radiologist, which I had never heard of. And I used to do a lot of injury defense as a young lawyer. And so I did that. And you're all saying, okay, what does this have anything to do with mediation? But my preparation, knowing that somebody was worried about the case, but they still weren't giving me authority. So my intuition was that the line adjuster and the lawyers were worried about the case, but somebody above the handling adjuster wasn't convinced that there was a lot of damage or that there was a lot of exposure. So I needed to convince that person, whoever it was, that there was exposure on this case. So I had the diagnostic radiologist take a look at some prior MRIs that I had in the medical records that defense counsel didn't have. And so I had him do this analysis. And just briefly, these 19 MRIs are all prior to the accident. And you can see here there's space between the spinal column and the vertebrae prior to the accident, and then none after the accident. And so he was able to show that it wasn't degenerative, that you don't have this, and then I had my orthopedist say that these kind of injuries were not or can only be traumatically or a result of a traumatic incident, not from degenerative disease. And then what I did is I went back. He had other things. He had broken tooth. He had to have a knee surgery. He had just a lot of other injuries. So I went through the jury sheets and I found cases and jury results on each one of his injuries, and I gave him these images, even though they didn't get them when they subpoenaed the files. And I gave it to him about 2 months prior to the mediation, and so they had my mediation brief looked like their large loss report, right? It had the jury sheets in there. It showed from an expert that they didn't have, with evidence that was unrefutable, that he didn't have these degenerative problems prior to the accident, and then ultimately we got a multi-million-dollar settlement offer out of them. So understanding how the insurance works and doing it, what you need to do in advance is what is the key in a lot of cases to getting them resolved. The again, I put this in here twice just because I think it's so important. If you can exchange initial settlement positions, try to narrow define the key issues that the mediator can then just take those and start ahead of the game, and then that also helps reduce posturing during the session, because you don't have to get somebody to give up on an argument that really doesn't, that is just a loser, because you've already done that prior to the session even starting. Mediation briefs. The in the mediations, all the mediations that I've done, I really am surprised at the wide range of the content of the briefs. I get some that really are just like a summary judgment motion. They're filled with law, like we're making a decision. Mediators are making a decision. We're not there to decide any issues. It's not having some concept of what the instructions to the jury may be is helpful, but it's having a summary judgment type motion really is. We're not here to decide whether there's a dispute of fact. We're here to decide what the best number is that both sides will agree upon, and control their own destiny that day, and not have somebody else control their own destiny. And so just sticking to the facts and the key legal issues. And again, I urge everyone to fast forward and focus on the cases and use those as part of the brief, so we really understand what the jury is going to have to decide. And then have an explanation of what the client wants out of the case and why the client wants it. My first job was with a small firm called Crivis and Passavoy, and Crivis was Jeff Crivis, and I'm assuming that most people on this line know who Jeff Crivis was. And so that was 1993 when Jeff was first trying to get out of being a litigator and get into mediation. And so I saw his transformation into a mediation. And the one thing he told me as a brand new lawyer that I've never forgotten was that you can give a number, and they're not going to, often they're not going to like your number. But if you give them a number and a reason, then they've got to deal with your reason. They can't just dispatch your number. And so I've tried to do that even in my mediation practice. I try to give the other side, okay, here's the number and here's the reason why they want that number. And if you give the mediator an explanation of what the client wants out, what your client wants out of the mediation, it helps the mediator convey numbers with reasons, and that often is really helpful in resolving the matter. Again, exhibits are great because that's what a jury or an arbitrator ultimately are going to rely upon. People, if they have two versions of the facts, the jurors often will just go straight, to the documents to try to figure out who's telling the truth. And so, showing where, if it's a business dispute or a real estate dispute, showing how the documents support your case is very helpful. And then again, send it to the mediator early enough to where the mediator can weave it in to his or her schedule to be able to review everything and call if there's questions. I like to do that an awful lot. If I get the brief, then I'll give a call. Hey, what about this issue? Or you've covered this. Can you send me this document? And I try to do a bit of the legwork before we get in, and I can't do that if I get the brief the night before. So let's chat a little bit about timing of a case. Is a case ready for mediation? Why are we mediating it? In real property disputes, you have to mediate cases before you file a lawsuit, and sometimes are you just mediating to check the box so that you can file the lawsuit? Yeah, and so you really don't have a choice. But in other instances where there's no requirement. All right, you got to have that discussion with opposing counsel. Are we ready to settle or to try to settle the case? Is there additional facts out there are there additional facts out there that one side needs to know in order to be able to resolve the case? If there's insurance folks, are there additional documents that would be helpful to be able to get the authority that's going to be necessary? And as a defendant, of course, it's always you've got that Hobson's choice. You've got the key document that submarines the plaintiff's case, or has the potential for submarine the plaintiff's case. If you give it up too early, maybe they try to come up with some excuse and try to get around it. But if you hold it until trial, then you've got no ability to settle the case, and then you spend a lot of money unnecessarily. Maybe not necessarily, but so that it's always it requires thoughtfulness about when you give up key documents that are helpful. But if you're a mind to try to save on litigation costs, consider giving up those documents earlier rather than later. And then again, do we need to have expert depositions in order to resolve the case? If that's what everybody agrees to, then I've had cases where I asked the parties to have their experts talk early in the case. Maybe even without counsel, go have a conversation and see if the experts can narrow the issues as between themselves, even without counsel being there. And that often is very helpful, especially in construction cases. They do that an awful lot. Who needs to be at a mediation? Now we've got Zoom, so people can. It's less onerous to have claims people attend. To fly all the way out to LA. They can be on Zoom. But get everybody there that needs to be there. If you have a claims rep, will tell you if they will be candid about that they're at their level of authority. Do you need to have a supervisor that's on standby? Is it helpful to have experts be in attendance or be available? But be careful there because I find that experts tend to want to hear themselves talk, and they can take over a room by trying to explain how wonderful they are, and then the key pieces of information that might be needed for resolution tend to go way beyond it. But it's another thing to think about whether having an expert there to explain certain issues can help a case. And again, the emotional challenges, is it helpful to have your client there in person with the mediator, so the mediator can, there's certain things that just can't be communicated over, a little box, and having somebody, present, and maybe that's a better way to go. And if your client is very worried about the emotional aspect of the case, maybe recommending that at least the client be there in person, even if everybody else is going to be present in Zoom. It really is a strategic thing to think about, and not just always default, like kind of that we all do now, that it's going to be via Zoom. The If you've communicated in advance, like I've recommended, then there's not going to be a wrong way offer or a wrong way demand. And what I mean by a wrong way demand is that you have a conversation, you say, okay, I'm on the plaintiff side and I want 100,000. And then in the mediation, you say, okay, my demand is $150,000. And then in the defense room, everybody's gnashing of the teeth and pulling the hair and saying they're going the wrong way. They're not acting in good faith, and then you get all the heat in the defense room that the mediator has to spend a lot of time trying to deal with. And so, if you've communicated an offer at 100, come to the mediation with 100. If something happened that requires or justifies the number to go up, then have that conversation before you get to the mediation. Hey, I know I told you it was 100, but it's going to be 150 when we get to the mediation, and here's the reasons. So that way, or on the defense side, hey, I had 50, but when we get to the mediation, I'm only going to have 30. And the reason is because, this happened, or, I submitted the last bill and now, my claims rep or my client doesn't want to offer that 50 anymore, so that everybody understands what's happening. If you're going to use an anchor, think about it. Is it right for this case to use an anchor? And I urge you to tell the mediator if you're using an anchor or not, so that way the mediator isn't confused, thinking, all right, because us mediators have a sense for what the case may be worth, and as we talk to the parties, have a sense for where the case should settle, and then one party comes and they're way outside, that range, and it gets to be confusing at times, and so you try to then spend time trying to understand why they're there. But if you just tell the mediator, hey, listen, I think that the plaintiff is really looking at this case wrong, and so I'm starting super low just to get them, to look at this the right way. And then that way, the conversation that the mediator has with plaintiff's counsel or maybe the client is much different than it would be if you just say, well, I think this case is worth 10 grand, and as the mediator, you're like, well, that's just ridiculous. If there's liability is found, this case clearly has a value of 60 grand. If you're going to use an anchor, communicate it with the mediator. Used cars sale strategy. You go up 5, I come down 5. You go up, and then the strategy becomes matching, the little bit of a move that was made by the other side. And if you've identified where you want to be and what your goals are, the used car salesman approach really is not that effective in most cases, and especially in catastrophic cases, again, because with every $5,000 move you make, that's another little cut to your client who was having their injury reduced just to a small amount of money, and it offers back and forth, and it gets to be pretty traumatic. The in those kind of circumstances, think about whether ranges or brackets. If you come up to 60, I'll go down to whatever, and try to narrow where that both sides might be able to go to with brackets. I had was on a seminar through the U.S. District Court when I heard about a strategy from a mediator that I'd never seen before, and I thought it was interesting. So I'm going to share it with you. It's called a three blind mice. And what the mediator does is he asks for a bracket from the defendant, and he asks for a bracket from the plaintiff, and both brackets are blind. Neither one sees the bracket. The mediator looks at both brackets, and if they don't overlap, then he asks for another bracket, and the parties do another bracket, and hopefully, of course, they widen their bracket because they know that there was no overlap in the first one they did, and then you look and see if there's an overlap, and then if there's still no overlap, then they do it again, and then if there's overlap there, then he reveals what the overlap is, what the number of the overlap is, and then the parties can start working towards that overlap, or the number that overlaps, or the range that overlaps. And so, but if there's no overlap by the third time, then obviously it's an impasse. So, when you've got a case that, instead of doing $5,000 at a time, think about whether you can, hone your negotiating skills by suggesting some creative ways on how to, get to where the number that everybody sort of knows you need to be, rather than just going $5,000 at a time. Of course, in the moment, I see this an awful lot. You have, attorneys that I get a sense, I know where they want to be, but then they'll make an offer that doesn't allow them. So, I know I want to be at 50, and so the other side's at 70, and then they say, well, let's go to 45, and then now you've trapped yourself, because you have no way. If they're at 75, if they go, let's say, even to 60, you don't have another move. And if you go from 45 to 47.5, then that might cause the other side to think, well, geez, I just came down a bunch and they're only moving a little, and then you have that problem. So, think ahead about what your next move may be, as you're discussing potential moves with the mediator. Just because the plaintiff makes a demand doesn't mean that the defense can't make the first move and come out with an offer. And there's no rules in mediation, and I always urge defense counsel, or if there's been an offer by defense counsel, have plaintiff make a move, or defense make another move. There's no rhyme or reason, and a lot of times I spend half an hour just trying to get somebody to make a move during the mediation, because both sides think that the other side should be making the first move. Don't make a second quarter play, or call a second quarter play in the fourth quarter. What I mean by that is, in the first part of the case, you're talking about facts, you're talking about legal positions, and if you're at a 4-hour mediation, hours 1 and 2, that's fine. When we get to hour 4 and we're trading numbers, I see a lot of attorneys that they want to start talking about the facts and the law that we've already talked about. Okay, well, that's second quarter stuff. Let's stay focused in the fourth quarter on the numbers, so that way we don't run out of time, and we can get the case resolved, and have an understanding that that it's a process. And when we get through the facts and the law in the first and second quarters, it's time to move along to getting the case moved. Now, sometimes things pop up, or new ideas come up, and so I'm not saying you can't, but there's some lawyers that I've had where it's like, okay, now you've told me about that statute 30 times, and I get it. I remembered it the first 27 times. So just don't be that guy or gal. Again, I said this earlier. I think this is the best, and I've seen this a couple of times, but I really like this definition. A mediator's role in a mediation is to find the number that the parties can agree to without having someone else decide that number. And it may not be the number that you like as an attorney, but if your client likes it, don't kill the deal with your own ego. I had a case a couple of months ago where I had to hear from the lawyer about how he hadn't lost an arbitration since 1997 or something like that. Every case is different, and you know, if the client is happy with it, and it fits this definition, then, you know, don't let your own, your own, what's the word I'm looking for? Belief in your fantastic litigation skills get into the way. On the defense side, you know, I know it's cachet. You got to do this to avoid defense costs, and I always try to avoid that argument. But you know, especially when there's insurance involved, or even when you're having a client, you know, paying money out of their own pocket, you've got to have that conversation. Hey, listen, I'm going to charge you more than what you can settle this case for today. And you know, and be upfront about it. Yes, I think this case is defensible. Okay, that's awesome. But if you're going to send your client an $80,000 bill to do that, and you know, the other side wants 50 right now, you know, you gotta have that conversation and have the client make a good business decision. And of course, you know, you hire the mediator for a reason. And, you know, often I see the attorneys wanting to make demands, and I tell them that's never going to happen. Well, I want to do that anyway. It's like, all right, so I'll go into the room and come back and say, as I told you, it's never going to happen. So, you know, you've hired the mediator for a reason. Consider their insights because they're hearing things in both rooms. And again, back to kind of what I earlier said, know what good enough looks like, and don't let the perfect settlement, which doesn't exist, you know, be your barometer. And I always have a settlement agreement prepared. You can pencil in the numbers. That way, when you come to an agreement, you don't have to start trying to find one, get one. I had a settlement that we had all hashed out. And in the 30 minutes that it took to find an agreement and to start putting terms in, the one party that really was on the edge about settling got cold feet and backed out. And so if you have a settlement agreement on the ready, then it's the way to make sure you preserve that deal and get it done during the mediation. Okay, so this is just sort of you know, a wrap up. You know, understand the issues in the documents. You need to have your client's expectations set by having candid conversations with your client. Have those communications with opposing counsel, and you know, have your mediator armed with a clear and honest brief about what your client's expectations are, and arrive with a mind of being flexible in your positions, with adequate authority, having gotten, you know, what you needed from your folks, your clients, well in advance of the mediation. So here now we've got the Q&A that I promised in the beginning. And we've got, as we've seen, as I've noted, a lot of good mediators that are on this. And so I'd be happy to turn the floor over and get some ideas or comments from others in the group, or even the litigators who have done things that they liked or didn't like or didn't work. David, you turn your video on, so I'm taking that's an indicator you got something to say.
Sure, I'd be happy to jump in. First, let me apologize for being so cash today. I don't have a tie on because I have the day off. And so the one thing that I like to do as a mediator, and I've been mediating for full-time for 21 years, is to make sure that I have an opportunity to speak with counsel separately and privately before the mediation session were to begin. It's like a day before, but after I've read the mediation briefs. And I don't usually go over substantive issues. I go over process issues. For instance, one of the questions that I ask is there something that you didn't want to write about that I should know? And sometimes that will be very revealing. And if I go further, I might ask, well, what's your relationship with the client? Is the client willing to listen to you as his or her lawyer? Will they take guidance from you, or or what have you. And what is this state of, what is their emotional state? You know, are they all bent out of shape about this? Or, you know, I do mostly real estate stuff. So a lot of times, you know, the people will get upset with one another, but they may not have seen one another. And so I ask whether it'd be okay for me to have a joint session in which usually I'm the only one talking. I don't like to have the lawyers, bait each other or have the clients argue. So, can they see each other? Can they listen to each other? What's the level of hostility? That kind of thing, so that I can manage some of those emotional components besides some of the substantive work. So I don't usually get involved in substantive issues, but I had a mediation 2 weeks ago where I got this beautiful brief from the plaintiff's lawyer, and I asked him if it came out of a summary judgment motion, just like you've discussed before. You know, sometimes I see a mediation brief that looks like it's been cut and pasted out of a demurrer. And that's not very helpful. And this beautiful brief went on for about 15 pages and missed the major issue completely. So I said, during the mediation, is it all right if I separate you from your client and have a little tete-a-tete about what I understand the law to be? I know I can talk about the law. I can't tell them what to do with it. He was chagrined to hear what I had to say and said, well, can you talk about it now in our phone conversation? And I did. And if I hadn't, he would not have perceived the risk. And what we do as mediators is we do risk management. And people can't settle unless they have some inkling of what their risk is of not getting what they want. So we had that pre-session conversation privately. It sped things up so that we were able to get it was a huge title issue. We were able to get the matter resolved in about 5 hours in session on Zoom. And so I always offer the opportunity for the lawyers to contact me and say, yeah, I'd like to have a private conversation. And if they don't, I might just call them up anyway, because I find it to be critical. That's what I wanted to say. Thank you.
So, David, you brought up a good point about in real estate disputes, the parties don't know each other, and that's one thing also that I've found. Because in trying to study the process of mediation, of course, we hear the terms conflict and dispute, and I've heard them being defined in different ways. But I take it as as the conflict being the personality or the relationships, and then the dispute being the subject matter that the parties are fighting over. And you have business disputes. You have partners that have 30 years or spouses. I mean, that's kind of where I thought about this in more of the family law sense, where you have spouses or business partners that are together for an awful long time. There's plenty of disputes, and they get over those disputes from time to time. And then something happens in the relationship that creates a conflict. And now the dispute comes up and they can't get over the dispute because this conflict in their relationship exists. But on a lot of business disputes or real estate transactions, the parties don't know each other. And so they have this dispute, and then they manufacture the conflict in their head. They think the seller must be this type of person, or the seller thinks the buyer must be this type of person. And so I try to take that head on in the very beginning, and neutralize that. Hey, I've had some conversations with the buyers, and they're pretty good people. I think you guys are, hey, you guys are kind of cut from the same cloth. I think you would enjoy, having a beer together to try to, remove that projected conflict that comes from not having ever met each other, like you mentioned.
Well, and on the other hand, there are cases where these partners have invested in a real property development or what have you. And things have gone wrong, and there's such a level of hostility, which we won't know about from necessarily from a mediation brief. And it's important to find out in advance whether they can see or talk to each other. On the other hand, very briefly, I've had, thousands, well, many mediations where the lawyers and the clients are in their separate rooms. And from Jeff Kitchaven, I learned long ago that it's okay to pull out the lawyers to talk to each other with me privately, as long as you ask permission, and usually everybody says yes. I've had a few occasions where the clients wanted to talk to each other without their lawyers. And, that's scary because this is all unscripted. The lawyers don't want to give up control, but mostly they'll go along with that. And then in those cases where people have had a heart-to-heart conversation with each other, in one instance, it was two dentists in a practice. In another instance, it was a father and daughter on a real estate issue. And so they got together with me without their lawyers, and were able to break through because of the personal connection. So it's scary as a mediator to do this, but we have to live dangerously sometimes.
Right. Well, we're getting close to the end of the hour, so just some final thoughts. Again, I think, and even with David's comments, it's that it should be obvious that settlement and mediation is a process, not a moment. And if you want to be successful, preparation is not optional. And your mediator is your ally. Use them as a negotiating coach. It's if you work with the mediator and you work with opposing counsel, you have a much better chance of being able to resolve the case. And so, thank you all for attending. I was happy to give this and share some of my thoughts. Again, of 30 years of litigating and trying cases, and then distilling that. I'll leave you with this. So, and again, at the very beginning of doing mediations, I was studying the process, and learning about there's a whole model about being more of a conciliatory personality as a mediator, or being evaluative, and I'm self-aware enough to know I'm an evaluative guy. I see things black and white. My grandfather was the same way. I learned it from him. And so I'm like, I'm not going to be evaluative. I'm not telling people what their cases is worth. In the first probably dozen mediations, all I got from the lawyers on both sides, and there was most of them that I did at first, that I knew the lawyers. They're like, okay, Mark, what do you think? And I'm like, I don't want to tell you what I think. But it's we all have to, if we do what comes natural, and again, it's as David just said, go with the flow, and hopefully we can all get these be successful in mediation.
Mark.
Excellent. Thank you so much, Mark. Really wonderful presentation. Thank you for sharing your insight and your time. Everyone, your MCLE slips will be sent hopefully later today. Enjoy the afternoon. Thanks again.
Thank you, everybody.
Bye.